Counsel for the record.
Good morning, Your Honor. Assistant Prosecutor Nicole Wallace on behalf of the state.
Morning, Judge Chris Decker, Assistant Monmouth County Prosecutor.
Good morning, Your Honor. Monica Mastalone on behalf of Mr. Paul Caneiro, who's present in court.
Good morning, Judge Andy Murray for Mr. Caneiro.
All right, good morning, everyone. Good morning, Mr. Caneiro. All right, so we're here this morning for several reasons. We've already had the pretrial conference back about a week or so ago, but we're back here today because since the last time it's actually a couple weeks ago, but since that last time, the court has rendered the last two decisions that were outstanding, dealing with the state's motion for certain intrinsic evidence to be admitted into court. The court's made that determination. The court has also ruled on the ballistics testimony in this case, indicating that it would allow that testimony at the time of trial. In saying that, the court at the last date also gave both sides the opportunity to file any in limine or evidentiary hearing motions that were due by last Friday, August the 8th by noon. I did receive several in limine motions by the defense, so those will be discussed today as a part of the overall conference that we're going to have this morning. We're also going to discuss some of the other outstanding issues that we still needed to discuss from the pretrial conference. So let me start with this. We have gone back and forth with the verdict sheet. It was supplied to me by both counsel. I had an opportunity to review it. I made some corrections or some stylistic changes and one correction to it and sent it back to the parties. At this point in time, are we all in agreement as to the verdict sheet as it's been presented and we've all reviewed?
The state is okay with the judge based upon the revisions that the court made.
Okay.
The defense agrees, Judge.
Okay, great. All right, so that one is taken care of. The second issue that we discussed at the last conference that I want to bring up again here today is the issue of note-taking. This trial, as it's presently scheduled for, is scheduled for September the 8th, and we're going to tell the jurors that the trial could potentially go to the third week in November. Because of that extended period of time, the court requested the positions of both counsel as it relates to note-taking in this case. On a normal case, you don't really need to have note-taking because the jurors could watch, they can remember. But because this trial is going to be so prolonged, I have brought up the issue for the both counsel to consider. While I have received some preliminary thoughts from both counsel as it relates to note-taking, I wanted to put it on the record here today because I do have some concerns that if we don't allow for some form of note-taking, that it would potentially create a significant number of readbacks later on when the jurors are deliberating. I should give you so that you have some understanding about what I mean by note-taking. So the way it would be set up is that each juror for each one of their chairs would have an assigned notepad. It would have the number on the back of the actual cardboard that would say juror number 1, juror number 2, all the way down to juror number 16. Those pads will be placed on their chair each and every morning by my court staff. The jurors would be able to write on them throughout the course of the day. On breaks, they would leave them actually physically on their chair. They wouldn't be able to take them with them. They would have to leave them right here. At the end of each day and at lunchtime, my staff would actually take those notepads, keep them. They would be kept in my chambers during the course of overnights and during the lunch hours so that no one would be able to have access to them and or be able to read them for any notes that they may have. And then they would be put back on their chair for the next day. As the trial goes on, if they have more than one notebook, we would give them additional notebooks as they requested it. and then they would be given the opportunity to use as many as they need. I would suggest that what we would do is, because they don't need to go back and refer to their notes during the course of the trial, once they were done with notepad number one, they wouldn't see that notepad again until they were done, and they can have that in the jury room as part of their deliberations. So that's kind of the way that I envision it. However, I'm open to suggestions from both sides, and or if your position is that you don't think note taking is necessary for this case. With that being said, I'll start with the state and your position as it relates to note taking.
Yeah, Judge, obviously I understand the court's concern, and the last thing that anybody wants is, a situation which seems to be far too common about readbacks and more readbacks and things like that. I'm just not so sure that the goal that we're trying to achieve is necessarily going to be assisted by the note taking, especially when the court's talking about how, if they finish one notebook, then they get another notebook. I'm concerned that it's going to become a situation, which is, I think, why jurors don't generally take notes, at least in this county, for the last several years. It's because it does breed somewhat of a less paying attention, as opposed to, hearing and writing. And I think just jurors paying attention is the best thing for everyone, in my humble opinion. That being said, I think if the court was going to kind of decide on its own that note taking is the best scenario, which the court can do, and it's not an issue that is going to leave me, crying at home tonight if the court went the other way. I do think, though, that the court should give that logical instruction that, hey, you don't have to write down every single thing. Like, this is just, the only reason we're giving you the notepad is because it's going to be somewhat of a long trial, and we want to ensure that, your recollection is recorded in some way at the times when it needs to be. I don't know, I just don't know. And I know that I Googled it very quickly after we spoke yesterday, and I forgot to go back and do it. I know there's a civil note-taking jury charge. I believe there's a criminal note-taking jury charge, based upon my recollection. And I know it's probably like a 2-page thing, and it may include some of that stuff. I will take a look at it. But I do think I worry that by trying to alleviate readbacks, we're now having a bunch of jurors that are going to be in a room for 3 weeks comparing notes during deliberations. And that's really what I worry about. I just think paying attention is the best way, despite having never been a juror, to be a juror.
All right. From the defense?
Judge, so with the understanding that the court this is an issue that's within the court's discretion, I recognize that. And I know it's guided by Rule 1:8-8B. With that said, though, the defense would object to note-taking in this particular case. And here's why. So I learned this fun fact about multitasking a long time ago, that we think that we can multitask. We can do multiple things at once, such as listening and taking notes. But actually what our brains are doing is just very quickly going back and forth from one task to another task. So we perceive it as multitasking, but our brains are actually just very quick at changing function, and we're not actually doing two things simultaneously. So with that said, Judge, I think our justice system and our New Jersey case law has recognized the concerns. In State versus Jump 261 NJ Super 514 at 525, quoting another New Jersey case, Wigler versus Newark 125 NJ Super 179 at 182 to 183, they just expressed that the appellate division expresses some of the general concerns. And they state the reasons advanced against this practice, meaning note-taking by jurors, include the contention that the taking of notes by a juror may tend to distract his mind from the evidence which is being presented while he is taking notes, may distract the attention of other jurors from consideration of the evidence being presented, may tend to overemphasize either to himself or to other jurors the evidence on which he is taking notes. Further, that the taking of notes might tend to be a confusing element for those jurors not trained or skilled in the note-taking process. And I think we have to keep that in mind, Judge, that these jurors are normal people like us. They're not trained stenographers. And so I do think that the process of taking notes will distract from their ability to pay attention to the evidence. And more specifically, Judge, my concern is that, you know, we all know the case, right? Because we're the lawyers and your honor has presided over the matter. So if a witness is on the stand, we generally know what to take down, right? Because we know like what points we want to make sure to get to the jury. We want to make sure we know certain things that the witness is saying that we want to address perhaps. But the jurors are coming into this as they're supposed to be blank slates for the most part. So my concern is that they will not know what is important. We're just throwing a massive information at them. And I think unless and until you take a step back after hearing all the testimony, that's when you can start to kind of piece it all together and say, well, I think this is important. I think this is important, especially when you have it presented to them the way it is, which is by witness. So it is kind of piecemeal. So my concern is that you have a witness on the stand and they're talking about, you know, like maybe just describing generalities of the crime scene. And they're noting down all of these things that maybe aren't actually relevant, maybe not something in dispute by the parties. And then the witness says something important and they miss it because they're too busy taking notes about things that really they probably didn't need to take notes about. So I think my concern is that if we allow them to take notes, it's going to distract from their ability to actually to ensure that they are paying attention to what is important, to everything that's being said on the witness stand. And Judge, also, you know, I think that it would be an easy mistake to make given the complexity of the case and the multiple moving parts. So if we have a DNA analyst on the stand and they're talking about probabilistic genotyping, again, my concern is like they're going to be writing down maybe the basics of DNA and miss an important point about a more complex issue. I think also, Judge, the problem with note taking is that you're looking down a lot, right? I mean, we can type without looking down, but we typically can't write without looking down. So I think it's really important for each and every question that is asked of this witness and each and every answer that the witness is giving, whether on direct or on cross, that the witnesses have the opportunity to have their undivided attention on that witness so that they can observe body language and they can observe eye contact and they can observe the characteristics that your honor instructs them on in the beginning or at the end and says, when we talk about credibility of a witness, you can take into consideration all of your observations about that witness. And that could be missed if they're looking down while they're writing. In addition, Judge, the jurors should be looking at the actual evidence that's displayed to them. So they might miss, like, if, you know, if the state has a detective on the stand, the detective is showing crime scene evidence. They might miss a detail if they're looking down. I also agree with the state that it will cause the jurors to rely on those notes rather than their own memories. And because they're not trained stenographers and they can't shorthand every single thing that's being said, they could make mistakes in their notes. They could mishear something and now it's memorialized. And now the jurors are inclined to rely on that as opposed to what their independent recollection is. It's easy to mishear testimony or mistake it and write it down and then later inappropriately rely on that. And again, when we're dealing with more complex forensic sciences, that is I think a higher risk that could occur here. The notes could be partial or incomplete and later misinterpreted by the jurors. It also lends to a possibility where jurors are, certain jurors who have better notes, so to speak, or more thorough notes, so to speak, might kind of take on a more leadership role in the deliberations as opposed to, I think, the ideal dynamic, which is that each individual plays an equal part in the discussions. You know, even just—
You don't have to keep going. I'm going to agree with you. If you want to keep going, though, you can.
meaning your honor is not going to order the
Correct.
taking? Okay, thank you, Judge. With that, I'll submit.
Okay. The thought behind it was exactly what I said. Based upon the positions of both parties, I will not order note taking under the circumstances of this case, and we'll go forward and see how it goes. All right. Next is the issue of we have discussed the statement of the case. Obviously, the statement of case will be provided to our prospective jurors to make sure, just based upon the limited information that we give them, whether they're going to be able to be fair and impartial or not. Both sides have had an opportunity to look at that. I'm just confirming that we are good on the statement of the case, correct?
That's correct.
That's right, Judge.
All right, next is the preliminary charge preliminary model charge that I gave to the jurors, or excuse me, that I gave to the council, that I would read to the jurors after we go through the initial screening process to get jurors that would be able to sit for the period of time for this trial. Did everybody have an opportunity to look at that preliminary model charge, and is everybody okay with that?
We are, yeah.
Judge, I did have an opportunity to look at it, and I appreciate that the court incorporated many of those questions for the searching voir dire. If that's what your honor.
Not there yet. I'm only on the preliminary model charge.
Oh, yes, Judge, that's fine. Thank you.
Okay, all right. But I'm gonna get to that, I promise. All right, so let's talk about now the voir dire question. So for the record, the court put together a list of voir dire questions, which includes a lot of the searching voir dire questions that the defense was concerned about. Normally there's 28 or 29 questions. We now have 39 questions to make sure that we address these issues. And I want to be abundantly clear, if there are any questions that I find that a prospective juror is waffling on, I will dive in and make sure that I ask a significant number of questions to make sure that we get a fair and impartial jury in this case. But I did try to address all questions that the defense were looking for as it relates just to the yes and no questions. We'll get to the open-ended in a second. But in saying that, does anybody have any issues now with those questions, the 39 questions that we have?
The state does not, Judge.
Okay,
I think it's 38, Judge, because we took out that 33 and replaced it.
you're correct. We did. We moved that. We were gonna make that in the open-ended question. So there's 38 now, but you're correct. So from the 38, any issues with that?
I don't have any issues, Judge. I just wanted to ask for a quick clarification.
Of course, go ahead.
Which is simply that when I originally submitted my proposed change of venue related searching voir dire questions to the court, they were obviously open-ended, and the court converted them to yes or no's.
Right.
So I just want to confirm we're doing this in the traditional sense that when the jurors have yes answers, we'll call them to sidebar and discuss them. So there may be some follow-up at sidebar.
Yes, 100%. So what will happen is that after we have a large group of qualifying jurors, we will then bring up somewhere between 50 to 100 in this courtroom. We'll put our first 16 in the box, but I'll ask the entire group all of these questions. They'll have a check off sheet that will have just each number where they can check off all their yes answers. I will then start with juror number 1 and ask them, do you have any yes answers? If they do, I will go through each one of them with them. I will probably do that, a majority of that, at sidebar. To be clear, we're going to do sidebar right in front of here. We're not going to do it on the side. So you'll come up with your notepad. We'll make sure that if you want, for Mr. Caneiro's purposes, that if he wants to have headphones so that he can hear what's going on up here, he'd have the opportunity to do that. Unless you want to do the shuffle method, that's up to you. And then I'll question that individual juror. Once I know that they're qualified or not, and with those answers, I would put them back. Once I get through the 16, then I'll come back. We'll do the open-ended questions together with everybody and the biographical questions with everybody. If that answers you.
It does. Can I make a suggestion, Judge?
Sure.
/ maybe an objection. I would just ask that the open-ended be asked at sidebar as well. I think particularly in a case like this where we're talking about people's opinions about, firearms and things of that nature, I would prefer to have people feel like it's more of a confidential conversation than have other jurors hear their responses and perhaps tailor their responses or be not as forthright with their answers if they're strongly opinionated people. So I have had, judges suggest doing open-ended questions, out in the open, but I've always, successfully convinced them, so I'm hoping I can successfully convince Your Honor that we do it at sidebar. That's how I've always ended up doing it, and I think it just, it preserves the integrity of like the open-ended question process.
Mr. Decker.
I essentially defer to the court. The court obviously has conducted substantial numbers of voir dires in the past. The one thing that we have to be concerned about is this not taking forever. And that I think is a primary concern. We want to get a fair and impartial jury, but we don't want it to take forever. And I don't personally think that it really should take forever.
And look, we're in a situation now where New Jersey, we are also looking at, in certain cases, not in this case, but in certain cases, doing attorney conducted voir dire where we have people's opinions are being addressed by everyone. And to the extent that a sentence that may be said by juror number 1 has an impact on juror number 6, that they feel differently or triggers them to remember something that they want to say. I don't see the need to do open-ended questions here at sidebar. I like the idea of having communication with them so that they feel a little bit more comfortable in here. So your objection is noted for the record, but I'm going to do the open-ended questions from the juror box. I know you wanted to say something, so go ahead, feel free.
I was just gonna say, Judge, I think it actually tends to be more efficient if we do it after the way that I've always done it is they finish all the yes and the no's, and then if we make it through that without them being excused, then we just say, okay, and we just have 3 more questions, and then you ask the open-ended, and again, it's more of a private situation. I agree with Your Honor, obviously, New Jersey's transitioning to ACVD, but that's not this case. And unfortunately, what we're unable to do here is ask the jurors, like, well, so how do you feel about the answer of juror number 2, juror number 14? We can't do that. So that's my concern is like, we're asking jurors to, express intimate opinions that maybe they don't feel comfortable expressing in front of others, and we may be deprived of knowing their true feelings. So if juror number 2 says, I hate guns, I hate everyone that owns guns, and I think that they're all bad people, then juror number 3 might not disclose, well, I think guns are great and I own 6 of them. Like that's my concern, because it's easy to avoid.
They may do that anyway. I mean, you're assuming that certain answers will be curtailed just by that. People curtail their answers just because they're sitting in a courtroom. Look, I hear what you're saying. The reality is this: you have one experience. This court has an experience that I feel extremely comfortable with the fact that we're going to do open-ended questions in an open forum. So I appreciate it. Your objection, though, is noted for the record. As it relates to the open-ended questions, now that one of the eliminate motions here today was to include a 4th open-ended question. The court, after receiving that eliminate motion from the defense for that open-ended question, as a result of the court's opinion as it relates to certain items of evidence that the state was going to produce, where the defense has objected to it, the court has made a ruling that it would allow that evidence in, that the defense had requested a specific question as it relates to gun possession. I had indicated that I would do that as a supplement, as a question, part of the yes or no questions. It was going to be number 33. However, after a conference yesterday, I believe it was agreed to that we would take out the proposed question number 2, open-ended question number 2, that everyone had agreed to, and now we're actually just going to take that question that dealing with guns, we're going to keep that as an open-ended question. We're going to make that question number 2. So we have 3 open-ended questions, and we have the 38 voir dire questions. Does anyone disagree? Did I say anything that was incorrect that we've all discussed?
Judge, we completely agree.
Okay.
Agree, Judge.
Okay, so that takes care of that for now. For my own edification, it applies to both sides. I don't know if the defense, this is even something that you would have to consider. Are there any witnesses in this case that are under the age of 18?
Judge, no, I do not believe there are any witnesses under the age 18.
Okay.
Unless I'm forgetting something, but I don't believe so.
Okay.
None.
If there is, for some reason, I need to be notified sooner rather than later, and don't call anybody in here without.
I'm largely confident that there's not.
Okay,
None from the defense.
okay, great. All right. So as a reminder, the trial, as I said, will be from September 8th. We're planning until November 26th, which is the day before Thanksgiving. We're going to hope to get that done prior to that day. But we'll see how it goes and how each and every day goes. But I want to tell you the schedule so that we have it for the record one more time. The courtroom will be open at 8 a.m. Every morning so that the attorneys can get in, they can get set up, whatever that they need to do. The defendant will be seated and ready to go by 8:20 in the morning. And assuming that as soon as he's seated, the courtroom then will be open to the public as soon thereafter. So by 8:22, 8:23, so that anybody that wants to come to watch the actual trial, they'll be able to get in around that time. The way that the seating will be set up is there will be 2 rows that will be set up in the back for the media, for any media that wants to attend. There are also this first row here right next to the jurors. That row will be only for people from the courthouse. We won't allow anyone that has an emotional attachment to the case to be seated right by the jurors, so that there will be no issue with that. We will inform any staff member that's seated there in that first row that they're not allowed to have any communications talking about the case or anything else. If they want to come and watch the case, they can. However, that they're not allowed to have any interactions at all with the jurors during the course of the testimony. We will have, for purposes of family members, we will have a court staff, someone from our court staff here to help escort them in so they have a place to sit, both for the defense side of the case and for the state side. So you can inform the people that are coming to just let the person know at the door, I'm here on behalf of Mr. Caneiro, I'm not here on behalf of the victims in the case, and we'll have them a row set up for that. Otherwise, it's first come, first serve, whoever's here, they get a seat. So that everyone is aware, there's a conference room right outside the courtroom door that will be set up with media in there. So that conference room will not be available for the attorneys, just in case you need a conference room for some reason. And then the courtroom right next to mine, that courtroom's going to remain open for overflow for people that want to come to the case and they'll be able to sit in there, they'll be able to watch it on a TV. Or if media wants to be in there, they'll also be able to be in there also. So just to give you an idea, we will have this courtroom, we will have the one next door, there will be a conference room. The attorneys should be cognizant of the fact that there is media that's going to be a part of this case, that you should be careful at both counsel table and outside of whomever that you may be talking to, or that things that could be overheard. So you just want to be smart in those conversations. You all experienced lawyers here. I don't need to tell you. I just want to make sure that you're at least informed of what's going on. As I indicated, the testimony will start at 8:45 every day. I do not want people to be late. Everybody in here knows me now. They've watched me through many testimonial hearings. I will be sitting on this bench at 8:44 and 59 seconds. So we should all be ready to go. Don't show up late, because then that will be something the court will address. We're going to end at 5 o'clock each day. However, if there's a reason why that we're very close to finishing a witness and either side says to me, can we just hold on and keep going? I will. All you have to do is tell me. If you don't tell me, I'm going to assume that we're not close and we're going to keep going at 5 o'clock, or excuse me, we're going to stop right at 5 o'clock and no later. As of right now, we will be going 5 days a week unless noted by the court. We've had some preliminary discussions behind the scenes as to maybe some potential days off. We'll discuss those more once we have a jury and we know exactly what we're doing. But you should be prepared right now that you're here with any of your cases or anything that you have else. You may have other responsibilities going on. You'll be here every day. Like I said, this case will be live streamed. Be careful with the mics, counsel table, and sidebar, things that you may or may not say. We discussed this in conference before we started here this morning, any potential stipulations or consent orders. I'm not going to get into specifics of that, but if there are some that are, there is going to be certain stipulations. Here's the court's order as it relates to them. If there's an agreement, the two sides will actually write it up as to what the stipulation is or a consent order that you've agreed upon. That stipulation, you're going to tell me if it's the, you want me to read it, if it's a witness, if it's the, the prosecutor is just going to read it, or if it's a defense witness and you're going to read it. I don't care who reads it. That's up to you all. But just know that I need to see it beforehand. The stipulations will be signed by the attorneys. It'll be signed by the prosecutor's office, by the defense, and by Mr. Caneiro. You need to understand any stipulations. I will question Mr. Caneiro outside the presence of the jury with the stipulation to make sure that he has seen it, he agrees with it, he has signed off on it, and that we're all ready to go. So just make sure that we've covered that. And then have two copies. We're gonna have one that's signed, which will be for the court, and then one, just remember, a stipulation would go into the jury room for deliberations. So that one will not be signed by everybody. I don't want that to be, that's not necessary for the jurors to see. I'll explain it in a jury charge. So, but the signed one, so we'll have two copies. Sign one for me, one that'll go in for the jury. Any questions on the consent orders or stipulations that we need to discuss? State?
No, Judge.
Okay, defense?
No, Judge, I mean, I understand the court's indicating the court would like the Mr. Caneiro, the defendant, to sign the stipulation, meaning that he has no objection to it.
Yeah, that's all he's saying. He's not agreeing to he's not doing anything other than saying that basically that he's in agreement that we're stipulating
He's
to this.
stipulated at the
That's
trial
it.
by the parties.
That's it. Okay, we discussed this before, without getting into specifics, transcripts. All transcripts, we ruled on certain transcripts as it relates to coming out of certain facilities. And I had indicated if there was something that becomes relevant during the course of the trial that I would not foreclose the state. However, are all other transcripts, have they been turned over?
Judge, they have, yes.
Okay, and if Ms. Massalone, have you had the opportunity to review them? And are we in agreement as to whatever they say for each one of those particular calls or whatever else that's being transcribed?
We're talking about the transcripts of the body worn camera.
Well, not just the body worn camera, the other transcripts also.
I haven't received yet the transcripts for the jail calls that the state was intending to use. I thought they were gonna narrow it down.
I thought that was done as of July 31st and that
The transcripts have all been turned over.
Right,
That's-
of the 200 jail calls, but then we had discussed that the state was gonna narrow down, at least narrow down which calls they were gonna use, so I could supply, my proposed redactions and objections. So I followed up about that, but I don't have that yet.
Mr. Decker, before I respond to this, go ahead.
I don't recall the court imposing an absolute deadline on where, I could be wrong, on which calls we were going to use. We are still working.
Not on the calls. Here's what I said. I said that jail calls that will be used must be identified by July 31st. All transcripts for those calls by July 31st. I said any objections to those calls would be by August the 8th by noon. And then I said the state will be allowed to use other potential jail calls if they become relevant based upon testimony during the trial, or if the defendant indicates something that would be inconsistent with a jail call, that would be something that could be considered if he decides to take the stand. That's what I've said at the last time that we were here. So to go back, whatever calls that you're going to use, have you indicated to the defense, these are the ones, and you've provided transcripts?
Can you ask that question again, Judge?
Sure. The jail calls that will be used during the course of the trial, have they been identified and told to the defense?
They have not been identified. The transcripts have been provided, but they have not been specifically identified.
Okay. All right. Because there were so many, what I had indicated is that I would not bar you from using as many as you need if they become relevant later, but out of fairness, if there were certain ones that you know that you were using, I suggested that you turn those over so that the defense could look at those transcripts so that we're not in the middle of this trial and we're fighting over what a word says in a particular transcript.
I know that we discussed, I recall the specific discussions about taking out the global tel link. This is a call from inmate Paul.
Correct.
Et cetera. I did not recall having this specifically. I'm not saying that I'm right. I'm just saying that's just my recollection. That being said, you know, we're aware of what the court said. If we can move for reconsideration by providing a small number of phone calls that we intended to use without the need, without consideration of others that would.
How much time do you need to turn it over? The numbers that you're gonna call?
By Friday.
Done. So by Friday, which is August 15th, by noon, that they should be turned over. Any objections should be responded to by August 22nd, 1 week later by noon. If there's anything that needs to be addressed by the court, notify the court by August 25th at noon. And then I'll figure out a return date if I need to.
Yes, and-
Hopefully we don't need that.
Yeah, and Judge, it's not a lot. It's not going to be a lot.
Okay. All right. As it relates to, now we'll go into the other ones. Body worn cameras, all that, we're all good with?
Yes, I just wanted to confirm, just for my recollection, I know that Ms. Mastalone had sent over certain changes that she wanted made, which we agreed with. And I know that we put in place having them made. I believe they've been provided, but I just wanted to confirm that.
Yes, they have.
Okay.
Those transcripts were provided. The state did indicate previously that it had agreed with all of the defense's proposed changes. In all candidness, Judge, I haven't reviewed those line by line. I'm trusting that they incorporated them, but I will do so, you know, before in the near future to just to be sure.
Okay. Are there any other transcripts or anything else that I haven't mentioned? Because I don't want any issues coming up.
No, there's not.
Uh,
Nothing that hasn't been discussed previously. Everything's been turned on.
Miss Massalone's about to stand up, so maybe.
No, Judge, I was just gonna also note, we did also receive redacted body worn camera transcripts as well.
Okay.
Those were also provided.
And were you comfortable with those?
We're still reviewing those, Judge.
Same timeline if there's an issue.
No problem.
Bless you. Yeah. All right. Okay, I did receive the proposed witness list, which is approximately 8 pages long of witnesses. This includes all witnesses, correct? Both the state and the defense?
Yes, Judge, with the only caveat being that if like we discover along the way that there's one person we inadvertently missed, we are gonna bring that to the court's attention as soon as possible. But yes, I did add the defense witnesses. I didn't delineate state from defense. So that's that.
Here's the thing. I understand with the amount, how the complexity of this case that you maybe have missed someone. But when, by September 8th, when that rolls around, you got whatever it is, whoever's on this list, that's it.
That's more than fair, Judge. And I don't expect that to become some sort of issue. I just wanted to kind of protect myself
I
in
understand.
advance. And I also do expect that by September 8th or before, I may be able to give you a more manageable list that you can slide into that jury booklet.
Right,
I don't,
which we do need, yeah.
I understand. I'm just, we're still working through some of this stuff. And also there's names on there that like just maybe heard. So I think it's appropriate. Like we've discussed this previously on the record, so.
Sure. Ms. Sloan, do you disagree with anything that was said, or is there anything about the witness list that the defense objects to?
No, Judge, no.
All right, this will be the witness list. To the state, thank you for the other list that I had asked for, so I have a basic understanding just in going through voir dire. All issues for the defendant's clothing, has that been settled and taken care of? Is there any issues that I need to know about or get involved in?
Not at this time, Judge. We've been in contact with Lieutenant Hansen. He was on vacation last week, so now that I think he came back yesterday, so we're in the process of coordinating with him.
Okay. Any issues, please supply them to me immediately so I can get assistance to you in any way that you need it. Any other security concerns that I need to know about? I know I addressed this before and everyone said no. Just want to give everyone another opportunity. Is there anything that the court should be aware of that I'm not aware of right now as it relates to informing the sheriff's department?
Not that the state could think of, Judge.
Okay.
No, Judge, I was going to ask at some point if we could reserve this front row for family members. Just, I don't know, something for the court to think about. I
It's
know
going to
that-
be that side.
Okay, yeah, that's perfectly fine, Judge. I was just hoping that if we knew the designated area ahead of time, we could work that out.
Yeah, you mean who gets the first row and who gets the second row? When I reserve it?
Either way is fine, Judge.
Yeah, I'll let you know. Yep, no problem. Other than that, I've indicated that when we got to today, all discovery has ended. I'm confirming there's no other discovery related issues that are outstanding. We're not gonna have any more discovery except for if a witness that you're prepping that may say something that you have the continuing obligation to turn over. But other than that, everything that you have has been turned over and we don't have any issues.
Yeah, Judge, I don't foresee any issues, Judge. I mean, we've been providing discovery for years now. And the majority of that which has been turned over more recently is as a result of further inquiries and, things that maybe they pointed out that we didn't realize weren't provided. We've tried to do our due diligence. We've assisted the defense as best we can. We've also, I know it's a little bit of a different issue. We've already met twice in our evidence vault with the defense, meeting with them again today. So we're doing everything we can to work professionally with counsel to make sure that, anything they need and vice versa.
Okay. From the defense?
I agree with that, Judge. We've met numerous times and had the opportunity to review evidence in this case. The state's been very accommodating in that regard. I do appreciate the court's directive that no additional discovery be provided at this time. As the court knows, with respect to the preclusion of the media or the electronic communications motion, that was a little bit of a hassle, but it's been worked out. So I would just, again, ask that this be it. 'Cause
And there's
doing a
no
lot.
requests outstanding? Any discovery requests that you haven't received the answer of? We don't have it, it doesn't exist, or we've already turned over? Is there anything else out there that I need to know about?
There's nothing outstanding. And the defense is meeting with the state one last time today to continue reviewing the evidence.
The physical evidence?
Correct.
Okay.
And there's been photographs that have been taken and those will be supplied to the state. Like, they haven't been taken yet, the ones from today. Those are just photos of the evidence that we're looking at. And then there's couple other photos, but other than that, Judge, yes, discovery is complete.
Speaking of photos, let's just do that now so we don't have to come back to it. Mr. Decker, I assume that the state will have some form of a photo book in this case of what you're going to be using. Do you have a timeline of when you're going to turn that over to the defense and to the court so that if there are any issues or if Ms. Mastalone wants to add some photos to it, we can kind of do it all at once before the trial starts? Have you thought about that at all or not yet?
I've certainly thought about the photo book, Judge. It will be marked S1. The only thing that I'm working on is obviously putting it together. I have different portions of it put together. For instance, autopsy photos. For instance, photos from 27 Tilton. We have the arson photos that have already been used, some of the Watson stuff. So I'm just deciding whether or not it's going to be set up from a, like, 27 Tilton, photos 1 through 50, 15 Willowbrook, 51 through 80 or 1 through 30, depending on, just trying to finalize that. But we are still trying to finalize certain pictures. That being said, like, my intention would normally have been to provide it prior to jury selection, to the court and to the defense.
That's fine. What we'll do is that if you can supply it to the court and to the defense, if you have it by September 5th, which is the Friday before, I would appreciate that. What I would do is, Ms. Mastalone, is then that following Friday, because no photos would be going up on the screen in that first week, because we're gonna be picking a jury anyway, that if you had any issues with particular photos, you can let me know, and then I'll address them on the record. And we can go from there. I would also suggest, and tell me, Mr. Decker, if you're doing it a different way, that if you have certain photos, instead of having to go and try to upload them or try to get them on a computer or whatever it is, if you want to add those photos into the overall PowerPoint, you can do that. Now, I have experience in the past where attorneys say, well, I don't want to give it to them yet because I don't want them to know what I'm going to ask questions about. That could be your way of handling things. I really don't care. Whatever you want to do is fine. But I'm just giving you that option. I'm sure Mr. Decker would accommodate that request so that things would run a little bit more smoothly. All right.
Thank you,
We would.
Judge. One other thing that does remind me that I haven't received it from the state, and vice versa. We've sort of talked about it, is just, I know both parties might intend to use some like Google Maps photos with certain witnesses, maybe just to show like your house is located here and this is where 15 Willowbrook is, or this is, so I don't have any issue with the state using the Google Map photos, and so I don't need them super ahead of time. And I would just ask that the state accommodate the same. I don't have all of my Google Map photos just yet.
Okay.
Yeah, that's fine.
All right.
That's fine.
We did talk about that, Judge.
I know we have used a couple during the Watson hearing, I believe.
Yeah.
But yeah, I mean, I would probably use fresh ones or that sort of.
Are you going to be, just so that I know, you're going to be using Google Maps from a 2018 version? So it looks like it did then, or is it whatever it is now that you'll be using? I don't really care. I just want to, just so that I know that if I have anything I got to deal with.
It's a fair question. I will give it some thought and let the court know it's fair. It's fair. I mean, I think certain places, depending on what they are, they look the same.
Right.
Certain places, they're obviously different. I mean, we were to show an overhead map of 15 Willowbrook right now, there's not a house there.
Right.
So, I mean, yeah, but it's a fair question.
Okay.
And the ones I anticipate, Judge, I can let the court know, the ones I have, like when you go to, Google Maps or satellite, Google Earth, you can change the date. And I think like the closest to November 2018 was, it's either June or September 2018. It's very close. So I think some of mine are going to be that. I have no objection to the state using ones that are updated if just the foundation is laid, like this was taken later and this is changed or something.
Okay. All right. Perfect. All right. All right, so the photo book 9/5 by noon. Okay. All right, now let's talk about the issue of the eliminate submissions that were submitted by the defense on August the 8th. The first issue that I'll discuss is one that we've already, I think is already taken care of. is the request for voir dire dealing with the gun issue. Do we all agree that that request has been addressed? There's nothing further that needs to be done based upon the additional open-ended question?
We agree with that. It's been addressed.
Okay.
I would just renew the objection that I would ask it to be asked at sidebar, but that's all.
Okay, all right, and that's noted. All right, so that one is taken care of. Then the next one we'll talk about is to preclude electronic communications. So when the court made a ruling on, I believe it was August the 5th, as it relates to certain states' evidence, that it was going to be relying upon communications between the defendant and the victim, Keith Caneiro, the court made a finding that conversations that occurred on April the 10th and April the 11th, those conversations would, 2018, they would be admitted. And then also dates in September, dates in November, and then the night before this actual incident. The court also had made a finding earlier back in the early part of July. It was around July 10th. I don't have the exact date in front of me. It was a motion by the defense to bar certain evidence from being admitted. It's a suppression motion based upon State versus Missick. The court agreed with the defense that the information that was taken from the defendant's phone should be limited only to the dates surrounding the actual offense based upon the affidavits that were supplied to the reviewing court at the time, which was November 19th and November 20th, 2018. In that decision, I had indicated that the state would not be able to use evidence outside of those two dates from Mr. Caneiro's phone, that they would have to find those communications that they wanted to rely upon based upon another independent source. The state has, when the court made this ruling on August the 5th, the defense had brought up the issue that some of the communications that were relied upon by the state in that motion that they're not located in any other area in the discovery. I had informed the state that they were to find that information, or if they could not find that information, that the court's decision obviously would have to be altered as it relates to these items of evidence. We had a conference this morning. It is my understanding now that there are certain communications that were not present in any other area of the discovery. And I'll allow the state to put that on the record so that we can flesh it out and make sure that the record is clear. And then we're going to come up with a resolution on how that will be documented. The court had talked about a consent order that both sides agree of what you could use, but I'll allow Ms. Wallace to explain this, and then we'll come up with that conclusion. Go ahead, Ms. Wallace.
Thank you, Your Honor. That's correct. There were text message communications on April 10th and the 11th, and then September 6th that were not located anywhere except on the suppressed phone. So the state will not be using those, and I can submit to the court. I think Your Honor wanted the specifics of what they were.
Yeah.
I can submit that.
Okay. So anything that is not within your brief, or that was in your brief that's not within that discovery, that should be precluded and from any testimony in this particular case, because you don't have an independent source. Ms. Messalone, you want to address any of that other than what I just said?
Judge, I would just agree with that. I think we can accomplish it by way of a consent order that just, the April 10th, we could say for example, the parties agree that the text messages that the state discusses that occurred on April 10th, 11th, and September 6th outlined on the respective pages in their June 13th brief are precluded from use or admission at trial. And then the parties agree that the remaining 3 conversations that are listed in the defense's original certification and updated letter, which is September 13th, September 17th, and November 5th, that those are admissible. The concern that I have, Judge,
Well,
is
some of the April is there, correct?
not the text messages.
Not the text
I
messages,
think
but
the state
other
referenced
email.
an email.
Yeah,
Right, but the defense was never challenging the emails. The defense is only challenging the presence of text and electronic communications.
Okay.
Not email, because we were able to discern the emails from the data that we originally had.
okay.
I understand that the state is indicating, like, for example, I think we discussed in chambers, there might be something over the summer, and it was sort of summarized as facts. It wasn't clear, like, exactly, at least not to the defense, exactly how they were intending to get that in. So if those are specific text communications, I would just ask that the state, I don't know, identify them, or at the very least, double check that they're there and provide a certification that they're there. Because it's very tedious for the defense to have now been presented, now we have access to this program that the state gave us yesterday, which now we can pull up these conversations and we have to go through them. And I want to just, for the court's edification, and put a footnote in my letter, like, it's not like when you go through a phone extraction and you see a whole conversation back and forth. It's not like you're reading it in the little speech bubbles, how we've seen. This is more unique. And what it is the state provided us with a program yesterday where it filters the data, and it kind of looks like how Outlook looks like, how an email, an email platform. And so each text message appears as if it's like its own email, right? And so it's not a back and forth. And the problem, Judge, is like also the text messages don't say to whom they are being sent. There's no identifier. It just says Keith is who it's from, and then like the message itself. So what the state demonstrated to us and what they told us and what we were able to discern yesterday evening is that what you can see is that there's messages from Keith to an unknown, but then there's messages received by Keith from, for example, the phone number assigned to Mr. Caneiro, right? So in context, it's like a message from Keith to an unknown that says, I'm just as an example, like, what time are we having lunch, right? And then the response from Mr. Caneiro would be, how's noon, right? So like if you read them back and forth and they're actually in consecutive order, it's like clear, it's Keith, it's Paul, it's Keith, it's Paul. We can discern that information. My concern comes into play with, there are other areas where Keith's texting multiple people at once. So you can't actually fully tell, who the messages are to if it's like kind of out of context. So, with, for example, these over the summer messages, I don't know if it's as clear as the ones that we're conceding you can put into context. Like, are these conversations continuous, or is Keith texting 5 people at once and every 5th message is to Paul? That's what we're surmising. So that's why I think it's a little bit more involved. And I think if the state can provide it ahead of time, at least we'd have the ability to double check ourselves, or if they accompany it with a certification, we could feel comfortable, like we don't need to double check it. They're saying it's there and that it's discernible.
Okay. Ms. Wallace?
Judge, the state will provide the order requested. We'll come up with a consent order like we discussed. I think it's my understanding that what's being objected to and what the state is agreeing we are not going to use are those April 10th, 11th, and the 6th communications.
September 6th.
I'm sorry, September 6th communications. As far as things over the summer, I don't even anticipate you really using any of that. I included that in the brief, but I don't foresee that. It's really.
Well, I ruled on a part of it, so if you decide not to use it, that's fine. Whatever you want to do, it's your case. just inform the defense that you're not going to use it. So then at least the record will be clear as to the fact that I've permitted you to use something and then you decided not to use it. That's fine.
But we'll come up with that consent order. We have to meet on other things like we discussed today anyway. And as far as the layout of that council was discussing of the actual, what the screen would look like, it's my understanding that with respect to what I memorialized in my brief, that what is there is not being objected to based on content, but the defense might request to have maybe like the full conversation in which the state would not object to.
So,
Just to the record's clear, we did object, but Your Honor ruled that it's admissible. You know, they filed the motion to admit under 4.4B and intrinsic. We opposed it. The court ruled that they're admissible. So we're
well aware,
obviously bound by
68
that.
pages of an opinion. I got it. Nice. So the court's not going to issue an order one way or another on this in limine motion. It's going to wait to get a consent order from you. That consent order should have in it, Ms. Wallace, please, discussing this in limine motion. As a result of the in limine motion, we have consented and whatever it's going to be. Okay. I will do an order for the voir dire, the gun, so that you have an order as it relates to that in limine motion of how I addressed it. Okay.
Thank you, Your Honor. Thank you. That's my
Yeah.
motion.
All right. So the next issue, next in limine motion was to preclude autopsy and graphic photos. This morning, the state provided the court with its photos. We've had an opportunity to discuss it briefly. We're not going to do these graphic photos in open court at this point in time. What I have asked counsel to do is to review these together. They're going to be together all day today. And they are to see if they can come up with some agreement. I've already given some preliminary thoughts on certain photos that I would have concerns with, and also understanding that the state may need certain photos for purposes of proving its case for each one of the victims that I would be inclined to allow. However, the defense has spoken about the potential of maybe stipulating to certain things. And if that's the case, what I'm asking the parties to do is to come up with a stipulation that both sides agree to as it relates to these photos. I don't care who reads it one way or another. But again, there will be 2 copies of the stipulation, one that will be signed by all parties and the defendant, and one that would just be marked and sent into the jury room after the case went to the jury. But I'm going to allow counsel, both sides, if they want to put any arguments on the record, to be able to do that now as it relates to the photos.
Judge, I'll be brief. I think we discussed this in chambers. I don't want to get too specific out here. I understand that some of these photographs are graphic. Unfortunately, that's the hand that we're dealt with respect to the horrific nature of these deaths. In particular, most likely or most probably poignantly with Sophia and Jennifer Caneiro, given the state of the bodies. We try to be guided accordingly. I understand that there was objections to certain photos. I understand they're going to argue that we have to think about the jurors and the reaction they may have. I get that. I've spent a lot of time looking at autopsy photos that I don't want to look at, quite frankly, but I looked at. And unfortunately, it's part of doing our job to prove the cause and manner of the death, whether they are, challenging it or not. I'm not going to get into it further. I look to the court. We look to the court this morning in chambers for some insight, because I am realistic in the fact that I don't want to go too far if it's not wholly necessary. Therefore, we will look to pare this down in conjunction with a potential stipulation. Like, I have given some thought to being able to say, for instance, in summation, that we didn't show you this because, quite frankly, it wouldn't be fair. It's so bad that, these deaths, etc. So I'll give it some thought. We'll discuss further today and be guided accordingly. And if we can come to a resolution, I hope we certainly can.
We'll have the same time frame that we had for the the other issues that we discussed, that by, if you come up with something, it would be due by August 15th together collectively. If you don't come up with something, I want the objections by then. And then I'll figure out a day to hear it after that. So it'll be August 15th if there is objection. But Ms. Massalone, I had indicated to you in chambers that I would give you the opportunity to object to these on the record, even if there is some ability to be able to come to some stipulation that both sides agree to. Go ahead.
Thank you, Judge. Just to clarify, did Your Honor mean August 22nd as
No.
in next Friday, or Your Honor?
No, because I'm gonna need more time.
Okay.
So I'm gonna give you to the 15th as it relates to this one.
Thank you, Judge. So yes, just with the qualifier that we did have the opportunity to conference it, and the parties have indicated that we're amenable to meeting and conferring and see if we can resolve this with a stipulation. I just in the event that we are unable to agree, or if the state beyond the stipulation is still seeking to admit certain photos, which I understand also may be the case, I just want to place the objection on the record. So I appreciate the court's indulgence with that. So yesterday afternoon, Judge, the defense did receive 25 pages worth of either autopsy or on-scene photographs that are graphic in nature. They amount to 50 total photographs. You know, I think it's actually pretty evident. I would say that the defense objects to a large majority of these as being either not relevant or unduly prejudicial. And I'll rely on the case law that I provided in my brief. I know the court's well aware of it. But I do just want to highlight, you know, I think the court really, part of its gatekeeping obligation here is to assess what is the actual purpose of each of these photos. And that's where the defense just wanted to take the time to highlight a couple of things. One, the defense doesn't challenge the cause and manner of death in this case. And nor, I know in the state's
Of any of the victims.
of any of the victims, exactly. You know, tragically, the victims in this case are deceased as a result of gunshot wounds, stab wounds, and or smoke inhalation. So that's not contested. The angles of the stab wounds are not contested, as they are identified in the ME reports. You know, again, I think the photos speak for themselves. How many, as well as the autopsy report. So how many bullet wounds there are, or how many stab wounds there are per particular victim, not contested. We did have the pretrial hearing with regard to the arson, so I understand why the state in its response brief was expressed a concern, like, well, what if the defense is challenging the time of death of the victims? And I clarified, we're not challenging the time of death. There's a lot of circumstantial evidence in this case that can lead any reasonable person to arrive at the conclusion that the murders or deaths occurred during a specific time frame. There's, again, we're not challenging that. So I think, you know, and I also indicated that, you know, there's a witness that the defense is not going to call. That's, you know, related to that, sort of tangentially related to that issue. So you know, if that assists the state or the court at all as well. That was Mr. Wood. So the point is, Judge, is like when we're looking at 50 photographs, right? And I had suggested, I know it's not the preferred method, but by the court perhaps, but the defense would suggest potentially a 104 hearing where even if it occurs right before testimony, where the ME gets on the stand and says, I need photo number 1 because of this reason, right? And then reason by reason, like, well, is this something the defense is contesting? Because if the defense is not contesting this, or if the defense concedes this, or if the defense can stipulate to this, why do we need the graphic photo? I think it was related to a different issue, but oftentimes the analysis is like, what is the least prejudicial means through which the jury can learn this information? And if it's just...
Isn't there going to be an issue as it relates to one of the defense experts in a report that was supplied? as it relates to the knife wound injuries? That there may be some relevance as it relates to that, or no?
Judge, I don't think so, and I can discuss that with the state as well.
Well,
Because,
there's photos in that report, right?
oh, right, but I also indicated in my reply letter, that if that expert testifies, he is not by any means relying on the photos in his report. He provided a trial presentation slideshow that only has 6 photos, and they're just sort of zoomed in on a little tiny wound. It's not.
I understand, but if that happens, then the state would have the ability to respond to that with photos that they feel may be responsive to that. So I'm just saying to you that it's not just in that vacuum that you're talking about, that it may become more relevant also during the course of the case. So I may have to make a determination first by saying certain things are in, certain things are out, but may have to readdress them depending on what happens.
And I think that's fair, Judge. I think the court's ruling with respect to the state's case in chief is separate and apart from the defense potentially opened the door to allowing photographs in. I think
got it.
that's a separate analysis.
Yep.
But with respect to only the state's case in chief, and let's assume for a moment the defense isn't even going to call that witness. If we're looking at it through that lens, I think that there should be, it should be placed on the record. There should be a mechanism where each and every objection is noted, as far as, again, the ME explaining, like, I need this photo to show XYZ, and the defense saying, we don't dispute XYZ. So we would ask that the court permit the ME to simply testify to these facts, or explain the facts to the jury, or explain, the condition of the decedent upon receipt. Like, those are things that can be explained via testimony, particularly in instances where the defense isn't disputing the information. So with that said, Judge, I think another part of the court's analysis here that's significant is, and I provided 2 articles. Did the court have an opportunity? I don't know, just with the court like a hard copy?
I have them.
Okay. Does the state have them?
Yes.
Okay. So Judge, I just want to highlight a couple of things, because when we make these arguments, right, it's unduly prejudicial, It's very vague and it's almost abstract. And I think what these articles help identify.
I read the New York Times article before you even supplied it to me, so I know exactly what it says. You don't have to reiterate it unless you feel a need.
Just as a broader principle, I think what both articles highlight is what the prejudice specifically is, right? It's not just like prejudice. It's that these jurors who observe graphic photographs can very much ultimately, it could result in not only trauma, but also it being a basis that serves to create a bias against the defense. And I think that that's what these are, particularly the law review article highlights, is that arousing negative emotions in jurors is not just an unfortunate but harmless byproduct of presenting evidence of certain injuries. Experiencing intense negative emotion can bias how people process information and to make decisions. Gruesome photographic evidence of, and they're referring to plaintiff's injuries, but let's say a victim's injury is particularly likely to rouse anger, which people tend to feel when they see an act of harm against someone that they perceive to be intentional, and disgust, which people tend to feel when they see a violation of a body. Psychological experiments have demonstrated that feeling anger and disgust can create a need to blame and punish someone to right the scales of justice for the harm that they have witnessed. And the combination of anger and disgust is particularly powerful. And they go on to cite some studies where they had, a mock trial with mock jurors, and group A only heard a description of the injuries versus group B, who saw the photographs. And essentially this article recaps how the result of those studies demonstrated that the people who were shown the photographs not only experienced like more of a disgusted response and therefore that they also experienced more bias when they were more inclined to convict or more inclined to view evidence through a different perspective, which was that it was not as objective to hearing out the defense. And so a lot of times their perception can be skewed in favor of conviction or in favor of guilt just by virtue of seeing the photo. And it's not conscious, it's not intentional, it's just human nature that, as Mr. Decker indicated, like none of us want to see these photos. And certainly, you know, at the very least, this is our job. The jurors, although technically it's their civic duty and their job, they can't pick and choose their trials. So if they're not emotionally prepared or psychologically prepared to see graphic photographs, it could not only harm the jurors, but also obviously then impact the bias toward the defense, whether it's conscious or not. So I think that the articles, I'll just place the titles on the record. It's the impact of gruesome photographs on mock jurors' emotional responses and decision-making. And it says in a civil case by DePaul University, DePaul Law Review, volume 69, issue 2, winter 2020. But again, although it's this particular article discusses a civil case, which the mock experiment is like the second half of the article. The first half of the article talks about how most of the case studies surround criminal cases and it recaps those, and that's what I'm specifically referring to. And the New York Times article is titled, "After a Grisly Trial, Jurors Are Left with Mental Scars and Few Resources." So I think, Judge, in light of the combined issues here, which is that we're dealing with an exceptional case here. We have not just one, not just two, not just three, but we have 4 victims, 2 of which are young children. And the injuries are particularly egregious, right? So there's multiple forms of injuries here. And when you combine all of those things, I think the heightened level of prejudice is exceptional in this case. That combined with B, the fact that the defense is not disputing cause, manner, method of death or time, creates a scenario where this court, I think, has to really carefully assess whether each individual photograph is actually necessary.
I'll do a
purposes of the
401 and a
safety.
403 analysis for each one,
Thank you, Judge.
if necessary. For the record, we're going to mark what the state has proposed. It's 25 pages. There's 2 pictures on each page, so it's a total of 50 pictures. We'll mark that as S1 for this particular in limine motion. So the record is clear as to what photos we're talking about. If you come to limit those photos, Mr. Decker, you can give me a new version and I would mark that as S1A or 1, 2 or 2, whatever. And we'll go from there. All right. All right. So that motion will be held for now until such time as I hear from everyone on the 15th. The next request is for a witness to testify outside of the media presence. That's a defense in limine motion. So I believe that's going to be heard on the papers, but Ms. Massalone, if there's anything that you want to put on the record, I'll give you the opportunity to do that now.
I have nothing to add, Judge. Thank you.
All right. And the state took no position. The court will do some more research on that particular issue before making its final determination, looking to get that opinion out either by Friday of this week. If not by Friday, then definitely by the beginning of next week, so everyone will know. I also want to point out that before I go to the other motion, is that I received notice from the defense that they are withdrawing their motion to preclude certain financial motive evidence that they filed in this particular case, and they're also withdrawing their motion to preclude Kimberly Patton's testimony due to the fact that the state has supplied experts, expert reports, 2 different expert reports to deal with the 2 issues that were of concern to the defense. Am I correct that these are being withdrawn?
That's accurate, Judge.
Okay. And for the state, you've turned over CVs, the reports, everything has been turned over, correct?
That's correct for both, yes.
And Ms. Mastalone, you have received those and had an opportunity to look at them, correct?
That's accurate, Judge.
All right, next. And I should point out with all of it, every time that I ask about this discovery issues that they've been turned over, Ms. Mastalone, you've also turned those over to Mr. Caneiro, so he's had the opportunity to look at them also.
Of course, Judge.
All right, the next issue is the defense has requested the court to reconsider the motion for change of venue as it relates to an opinion that this court has already ruled back on April 4th, 2025. In a written opinion, the court denied the defendant's motion to change venue, which was originally filed on March the 7th, 2025. At that point in time, the court had indicated that the defendant had not met its burden under Rule 3:14-2 and controlling precedent to show a clear and convincing proof that a fair and impartial trial could not be held in Monmouth County. The defendant now moves for reconsideration. I should point out, as I indicated before, that the defendant had filed this motion on March 7th. And at that time, the defendant moved for change of venue, citing cumulative local publicity. The Asbury Park Press concentrated readership in Monmouth and Ocean County, and the prevalence of hostile online commentary. The state opposed that motion, arguing that the coverage was factual and that the voir dire would suffice to ensure impartiality. On April 4th, this court denied the defendant's motion in a 53-page written opinion, concluding that 1, most coverage was fact-based and neutral. 2, no torrent publicity or carnival-like atmosphere existed. 3, social media commentary was not competent evidence of community-wide prejudice. And 4, that the comprehensive voir dire would adequately safeguard defendant's right to an impartial jury. On August the 7th, 2025, the defendant filed the present motion for reconsideration, attaching exhibits claiming to show 65 new items of news coverage since April the 4th, 2025. State opposed the defendant's motion in a brief on August the 10th, 2025. Defendant's argument now incorporated everything that was in the original March 7th, 2025 brief, and indicated that these 65 additional items of coverage since April, consisting mostly of Asbury Park Press articles, other news outlet reporting, and online commentary, the court should reconsider its decision of April 2025. Defendant emphasized that the volume of news coverage occurred in just 4 months, which he claims marks a significant shift from the court's finding of the peak coverage that occurred in 2019. Defendant argued that the most recent coverage has reinforced community awareness and hostility, particularly given APP's concentrated local readership. When I say APP, I'm talking about the Asbury Park Press. The defendant further asserts that much of the recent coverage was triggered by defense filed motion, but contends that the defendant should not be penalized for exercising its rights. He maintains that online and social media commentary remains inflammatory and reflective of local sentiment. On the merits, the defendant renews his claim for presumed prejudice under Harris and Marshall, arguing that the nature, frequency, and distribution of publicity now meets the threshold for a venue change. In the alternative, he requests that the court reserve decision until voir dire, at which point a finding of actual prejudice could be made if juror questioning reveals bias. The state, in its response to this August 7th submission, relies on its March 21st, 2025 written submission and oral argument in response to the defendant's original motion. It argues that the increased volume of coverage since April 4th, 2025 is unsurprising given the number of recent motions litigated, but that the coverage remains factual and does not contain name calling or opinion pieces such as those found prejudicial in State versus Harris. According to the state, the recent articles merely recount what each side argued and what the court decided. None constitute a torrent of publicity that creates a carnival-like setting or a barrage of inflammatory reporting, as noted in State versus Nelson. The state further notes that some headlines could be viewed as favorable to the defendant, covering the defendant's successful motions. Regarding social media commentary, the state argues that presuming hostility in the entire jury pool based on such comments would be premature and speculative. The state concludes that voir dire is the proper method to address any potential prejudice, and that the court may revisit the issue if jury selection reveals a realistic likelihood of bias. I tried to outline the arguments. If counsel needs to be heard further, I'll give you a chance to do that now. Ms. Mastalone, this is your motion on behalf of your client, so the floor is yours. I'm just asking you not to reiterate your brief.
Yes, Judge, just very briefly. I just want to highlight, when we talk about the pretrial publicity and the prejudice, it doesn't have to always be super negative prejudice name calling type reporting. I think what the court can also consider, which is more what we have here as well. I know I previously made the arguments about how the social media commentary can come into play with the negative publicity and how people see the social media posting and comments online. And I don't need to reiterate that argument. The court's aware of it. But with respect to the media outlets themselves, fact-based and neutral reporting can still be problematic. And here's why. Because many of these headlines, if you read through them, reveal evidence that is either going to be admitted at trial or that is not going to be admitted at trial. And they are both equally, if not unequally, they're both problematic. And the issue is that when jurors already have a sense of the evidence that is to come, or if they have knowledge of evidence that exists that they don't end up seeing at the trial, it creates a clear prejudice for the defense. I mean, the jurors, we know, should be as close to clean slates as possible. I know the case law says it doesn't have to be like completely clean. They can have a little bit of knowledge, but there's a difference between having some familiarity with the fact that this case exists and to know, testimony likely to be elicited when Paul Caneiro goes on trial and they go in, the article goes into detail about certain testimony. Pre-trial hearings provide sneak peek of Paul Caneiro's trial in this case. Surveillance video shows, and they're playing surveillance, there's
Do you
surveillance
agree that
videos.
some of your exhibits are actually duplicative? If you actually look at them, do you agree that some of them are duplicative?
As far as like the headline itself, yes, the medium is different. So some of it is like an Asbury Park article, some of it is Asbury Park Press posting on Facebook, some of it is Asbury Park posting on Twitter or
Saying the
X.
same exact thing, though. You would agree, right?
Yes, exactly. It's just that it reaches a wider audience, the more mediums that it's posted on. So maybe someone doesn't subscribe, but they see it on Facebook, or they're not on Facebook, but they're on Instagram or Twitter. So that was the purpose of showing, yes, so that the headlines themselves are duplicative, but it's separate content as far as the audience base.
Well, it's not separate content. You're saying that it's separate base that will read it, but it's not separate content. It's the same content.
When I say-
Or taking blurbs of certain content, correct?
When I say content, I was referring to the medium itself. It's separate mediums.
Okay.
The content of the information is the same, yes. But nevertheless, Judge, we're talking about surveillance videos and sneak peeks and evidence examined and motive evidence, alleged motive evidence, life insurance policy evidence. I mean, all of these things are evidence that jurors should not have any knowledge of prior to sitting on this case. And there's just I mean, that's the whole point of the motion, right? Is like, we're not saying that there's not some needles in a haystack here that maybe have no knowledge of this case or that have very limited knowledge of this case. But the purpose of highlighting, like, yes, these are repeated headlines, but here are all of the vast mediums that they're published on. And so they're reaching a wide audience base concentrated here in Monmouth County. And there's a concern that many of our jurors are going to come not only with this knowledge that is heightened in this case that they shouldn't have if they're sitting on the jury, but how that knowledge is going to cause them to prejudge this case or prejudge Mr. Caneiro, again, whether intentional or unintentional or conscious or subconscious. Beyond that, Judge, what is extra concerning are all of the headlines that highlight the suppression of evidence in this case. So no juror wants to feel that evidence is being hidden from them or that they're not having access to all of the information. And if there's a wide reader base of the Asbury Park Press combined with the people that see it on social media, on the various platforms, there's a concern that, jurors are going to have that in the back of their mind, or have information
All of
that's
your
not
arguments are
admissible.
making a lot of assumptions, aren't they? Under the circumstances, and also where we are today is really not different than where we were in April. We have to at least have voir dire, that searching voir dire, then we're gonna know. So my concern is that, and I know you had indicated that the court could hold off on this and wait, but the court's position as it relates to where we are today is that the court, understanding its obligations to make sure that Mr. Caneiro has a fair trial, and understanding what I've ruled on already, that if I find prejudice, actual prejudice, at any point in time, I won't need either party to tell me that there's actual prejudice. I will do it sua sponte. I can tell you that directly right now. So I understand what your arguments that you're making. My concern is that we are again assuming certain things because we don't know until they show up, until they start answering us. Then we will know how wide ranging this is and how much people may care. They may have read something in 2018. They may not have read, they may have stopped getting the paper after COVID, who knows? Or they may have stopped reading online after COVID, who knows? So I hear your arguments. I don't know if we're in a different position today than we were.
The reason why I would submit we are in a different position, Judge, is simply because motions have been filed.
I understand.
As has been placed repeatedly on the record that up until more recently, no motions have been filed. Obviously, there's a change of counsel, motions have been filed, and I think that that's where this influx of headlines is coming from clearly, and it's unfortunately right before the trial is about to begin. I agree, Judge, we are assuming things, but I think that's the whole point of the presumed prejudice, right? It's not like we have to come prepared to show presumed prejudice. That's why it's distinct from actual prejudice, because we don't have data. We just have all of this information that could possibly, if the defense were to meet the standard, demonstrate to the court that, you know what, there's just so much going on here. We can presume or assume that the prejudice has met that threshold.
I got it.
So that's the argument, Judge, and I understand the court is aware of it.
Okay, great. State, going to respond?
Just very briefly, Judge, the state would rely on his previous submissions. The court outlined them very accurately. Just in response to the defense's arguments, I would note that, in terms of any prejudice more recently and overall, I'm just looking at the voir dire here. There are specific questions in here about that. And they will be asked those questions as the court indicated. So at this point, it's the state's position that any presumed prejudice is premature.
The defense motion as it relates to for reconsideration, it's going to be denied for two different reasons. One will be for procedural grounds. It's outside the time frame, but it also will be denied based upon the merits of the argument. You'll have an actual written opinion today that will provide the reasons for the court's decision. And here's what I will say, is that, I just said it to Ms. Mastalone, if this court will be analyzing each and every witness that comes in here as to, each and every prospective juror that comes in here. If the court finds that there's actual prejudice, that there is some pattern of that in this particular case, this court will at that point in time, address it with the attorneys. Otherwise, this court has decided this motion. It just decided it again today. And this court feels that if there's anything further that it needs, it will address it when the appropriate time comes. So with that being said, you'll get an order and an opinion today denying the reconsideration. All right, the next issue that is outstanding is, this wasn't a written submission, but it was orally brought up by the defense. So I wanted, and I said that I would address it today, was the objection by the defense to the seating arrangement in the courtroom. And Ms. Masalona, I don't know if you want to put anything on the record. I'm going to tell you straight up, so you can create your record, but I'm telling you right now, the way it's set up right now is the way it's going to be, based upon the limited room in this particular courtroom. We don't have a large area within the well to be able to move counsel table around. We have 4 people at defense counsel table right now as we speak. I don't know if there will ever be more than that or if this is what the 4 will be. So with that being said, we need the 2 tables that are set up. From my understanding, the state has 2 attorneys on this case, and they may have individuals that are seated with them to assist them with the trial. So there is no way to put this on tables on an angle. I'm not going to put attorneys and or their people that are assisting them behind them in this particular case. I also want to leave enough room so during opening summations and for you to do your direct and cross with the way that this courtroom is set up, that I want to have sufficient room for all the parties to be able to stand up and do what they need to do. Based on the fact where the witness stand is located and that the jurors are located across the room looking directly at the witness, this court does not find that there's any other place, another setup that can be done under these circumstances of this courtroom. I will also tell you, so if you want to address this also in your argument, is that this court does not intend on having that podium here for purposes of this trial. If you wanted it for your openings or summations, feel free, that's up to you. Otherwise, I will have a portable podium that you could put right on counsel table. So if you want to stand up and have it right in front of you, but then have all your other stuff that you may need for a particular witness, you'll have it right there. If you don't want that, then you won't need it. You won't have to have it. But based upon logistics, I can't even have a podium out here where you may be blocking the view of a particular juror as they're trying to analyze the evidence, especially in light of the arguments first thing this morning, wherein we're not going to allow note taking so that people can pay attention to the actual witness. So Ms. Masalone, with that being said, I want to give you the opportunity to place whatever positions that you want to place on the record, but at least out of fairness to you, wanted to let you know where I'm thinking, what I'm thinking.
Thank you, Judge. I mean, I think the court's explained, why we are where we are. It sounds like we have limited options. All I can say is I don't like it. I object that, but if, the court's going to rule how it rules, and if we have limited options, I understand the court's constrained as well. My only, perhaps misunderstanding was I thought that the witness was going to be in that witness box. For the record, I'm pointing to the one that's like next to the
Right
court.
where my law clerk's located right
Right,
now.
where the
Yeah.
law clerk is located, as opposed to, only because this one just feels like our backs are to the jury more.
I understand.
As opposed to this one. So I don't know if that's something the court can reconsider or if that's already been considered.
So yes, it has been considered. I'll tell you why, that we were of the opinion that we have to leave the witnesses where it is. It was because from where Mr. Hinton is seated, my law clerk, is that I'm not sure Mr. Murray can actually even see Mr. Hinton in his full body from where he is, or he has to lean over. So I was worried about a sightline issue for each one of you, and I don't want that. And Mr. Caneiro has the right to be able to see that witness. So that's the reason why that we can't have the witness over here, and we had to have the witness right in front of you. But if you have any thoughts, feel free. Believe me, we tried. But if I ask the county to do one more thing for me, then, I may get fired.
Yeah, I mean, I guess we can't move that one forward, right? It's stuck.
It's affixed.
Okay.
Yeah.
Then, I guess it is what it is, but, so my objection, just, I would note it for the record that
It's
this is
noted.
less than ideal.
Mr. Murray, if you don't mind me, I don't mean to put you on the spot, but from your vantage point, can you actually see my law clerk to be able to?
The top of his head, Judge, but
Yeah.
if I moved over for purposes of cross, I could see the witness.
Right.
From the end of the council table.
Listen, if you all prefer that, my concern was for you, not for me. I can see. So if you want to do that, think about it and you let me know, because here's the thing. If we're going to do that, then we have a wiring issue because that is wired. So we would have to, my division manager is in the back from IT is probably losing his mind, but we would have to rewire it over to here so that we could do it. So that's up to you guys. I don't mind either way, but that's the way it's set up right now.
Judge, the problem though too is, as Your Honor indicated, that Mr. Caneiro can't see.
That's the concern.
witness. And yeah, so now that we're sitting here from our vantage point, it's an issue. So I think we are probably constrained to use the witness box that is diagonal from the bench and across the courtroom from the jury. But as far as the seating arrangement, I would just note my objection for the record.
I understand. Look, and I can't tell you all what to do and how you do your directs and your cross and where you do them from. You can do them from council table. My suggestion also is you could do it from on the side next to where the jurors are and look straight across. If you want to get more of everyone focused on the witness and not on you and everything else, that's up to you. However you want to do it. The courtroom is yours for you to do your presentations. If you're going to do something that's extremely out of the ordinary, all I ask for you to do is let me know, so that if I have to deal with it, I'll deal with it. But other than that, again, I respect and understand what each side needs to do, and I want to give you the opportunity to do it. Believe me, based upon my experience, I've tried every other way to make this work. And if I thought that there was another way, I would do it. So, all right. All right. With that being said, let me see. Okay. I think we're coming to the end here. This is good for all of us. I did receive a proposed jury charge from the state dealing with the issue of life without parole because the defendant is eligible if convicted of any one of the first four counts of the indictment, that has the potential of life without parole. There was a proposed charge that was provided by the state. And I believe that the state has supplied it to the defense. The defense has had the opportunity to take a look at it. And are we in agreement or close to an agreement as it relates to the life without parole jury charge?
And I think we are either in agreement or very, very close to agreement.
Okay.
I don't have any issues.
I think we're in agreement, Judge. The state had supplied a proposed ad lib to the model charge, and I reviewed it, and then I changed it and submitted it to the state, and I conferred about it, and then we completed it and I submitted it to the court. I think we're all in agreement.
Okay, good. And I do have that. So for the record purposes, that is, we're all in agreement to that. Next. As it relates to pre-marked exhibits, we talked about pre-marking everything in this particular case. What I'm going to ask for is, once you pre-mark all of your exhibits, I'd like to have them uploaded into the share drive like you have shared other things for hearings. If you have any issues with that, I know you're going to be meeting with our division manager for IT. You guys can discuss that, but I'd like the pre-marked exhibits in advance, and I'm going to explain why, but I need them with the sticker on them already, with the number that you're going to assign for each one of them. So here's the thing, that during the course of the trial, you're going to be using these items. Some of these items may go up on the screen. Because the state will not be moving its evidence in until the end of the state's case, Same with the defense. At that point in time, we would be in the position of then trying to remark all of those, and then we may be getting requests for those items. Nobody can get any of them unless I have had the opportunity to review it. So if I have them all in advance and we can see certain items have already been marked, that they're probably going to be moved into evidence, we can at least have that process started, and we're not doing it all at once, because I don't want to create that kind of an issue.
Judge, just to be clear, you're talking about a list,
Well,
not the actual,
no, the list,
just
if,
the list, S1 through S200. Well, I don't understand that.
I'm asking for, tell me if it's too much of an issue, that when you're going to mark S46, which is, say, a financial document that's 100 pages long.
Sure. You want to-
I want to upload it into SharePoint, because that we're going to need the final version of everything that's going to be used and to make copies of it. If it's too onerous, you can tell me that now, but we're trying to figure out something. We thought that that would be easy for an upload, that somebody's marking them, somebody scans them in and uploads them into that particular drive, so then that we have them. If it's too difficult, you guys can tell me, but that's kind of what the thought process. If not, we're still going to need all of those exhibits at some point in time.
Can I ask for clarification? Your Honor had said something about moving the evidence at the end of the case, but I was under the impression that we were going to be moving in evidence through each witness. And so my concern.
What I'm saying is that a witness, you may ask them using certain documents or whatever it is. That's fine. The actual moving of those exhibits, I'm going to expect that the state's going to do it at the end of the state's case for all of its evidence, so that you can, if there's objections or issues or modifications, or because I won't know. If there's certain things that Mr. Decker wants to move in, and with a particular witness, and you have an objection to it, but he's going to use it on another witness later, I want it to be done at the end so it's clean.
But it can only be published to the jury if it's in evidence. So wouldn't he need to say to the witness, like, this is a photograph, and the witness says yes, and blah, blah, blah?
You guys are already going to have agreed on that, I am sure, of particular items. Yes, I understand the evidence rules, and I understand that if they go on the screen that they've already been moved into evidence. I assume that a lot of these are not going to be issues, because both sides are going to be using them.
Right, so that's why I think personally, I would prefer if we could just keep track by moving it into evidence through each witness as it's occurring, so that.
Can I see the attorneys in the back for a second?